mind leading us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States
Flag
of
of the
America,
United States of America.
under God, indivisible, with liberty and justice for all. That threw me off.
All right, well, welcome to the April 23rd Assessment Appeal hearings. We're gonna go into the regular calendar. Item 1.1, consider approving request for postponement as submitted by the assessor. And there's no contact on this. This is my first assessor's meeting, so I don't know, Margaret or Richard, you might have to help me through this one.
Jack Margaret was gonna kind of give us a rundown. See what I believe.
I can do it now. I was gonna do it right prior to that hearing that we're actually holding. My understanding, this is just a request for a continuance, so I think it would be appropriate to handle this first and then get into the actual item. So we can keep a clean record.
So
All right,
Jeremy, just so this is a kind of a placeholder on the agenda, in case we had multiple hearings and the assessor had a request for postponement. So I think at this time, I think we would ask if she does, and I don't believe that she does, but I'm gonna let her speak for herself.
No, I do not.
all right, sounds good. Then do we need a motion on this item, or do we just go on to the next?
You would move on to the next item.
Okay, item 1.2, swear in staff of the assessor's office. I apologize for not being there, but is there anybody there to swear in?
Yes. Please raise your right hand and repeat after me. I swear or affirm
I swear or affirm
that the testimony I'm about to give
that the testimony I'm about to give
in this matter
in this matter
is the truth.
is the truth.
And that's it. Thank you.
Thank you.
All right, item 1.3, receive assessor's request for findings of fact. Are there any findings of fact coming forward?
That would be if the assessor's office has any requests for findings of fact.
The assessor's office is not requesting written findings of facts.
All right, then we will go into our scheduled hearings. Item 2.1, consider assessment appeal number 2019-01 from Diane Richards and Diane D. Poole for APM 017-330-0900. And who do I pass this off to?
I'll take the first jump on it if that's okay with you, Chair.
Of course, please.
Thank you. I just wanted to have a brief discussion prior to commencing this. This is the first appeal hearing we've had in a while and the first one with this new board. And there's just some preliminary matters I wanted to go over and kind of establish how we're going to handle this. The first thing I want to make the board clear is you're sitting in a quasi-judiciary capacity today, so you're acting as a judge. The standard of proof that we're looking at is very important to know, and I want to make sure it's clear to that, and that's a preponderance of the evidence. And that is defined as, one moment, let me find it. Okay, the preponderance of evidence is defined as in terms of probability of truth, and as evidence which, when weighted against evidence offered in its opposition to it, has more convincing force and a greater probability of truth. So we always look at that as which one is more accurate. You're looking at a 50.1% of truth. There is a presumption in these hearings that our assessor is correct. The Evidence Code section 664 provides that it is presumed that official duty has been regularly performed. As a result, it is presumed in absence of contrary evidence that assessor regularly and correctly assessed the valuation of property. The burden of proof is on the appellant to show that's not correct, and again, they're doing so by a preponderance of the evidence. The procedure that we're going to move forward today is that the assessor will present the matter before the board, just give a preliminary overview. Then it will turn over to the appellant to provide any information or evidence that they believe is correct. You have an opportunity to ask any questions of the appellant. Once that's complete, the assessor will make her presentation formally if she has one, and you'll have an opportunity to ask questions. Once that's complete, we will close the evidence, and the board will have a decision to make about whether you want to deliberate in open session or whether you want to go and deliberate in closed session, which you can do under the code. If you go and deliberate in closed session, we'll clear the room. I will remain as your legal counsel to provide any advice going forward. An appellant has requested written findings, so ultimately we will have to prepare written findings, which will then be mailed to both the assessor's office and the appellant. That will be the procedure we'll move forward on today. The appellant will be sworn in as well before she testifies or provides any evidence. And then again, if you have any questions of the assessor, she's available to answer them. Any questions on the procedure?
So the assessor will make a presentation and then the appellant will follow and then the board may ask questions.
So the assessor will present the item. This will again just be an opportunity for her to present the item, and so we know what property we're handling and what the issues are on it. Then it'll be turned over to the appellant who has the burden of proof to make her presentation. Then the assessor will make her presentation following that if she has any argument or additional information she wants to provide. Again, you have the ability to ask questions along the way.
You as in the chair or you as in the board?
The board as a whole has the ability to ask any questions through the chair. They would request your permission. Questions.
All right, are all the board members clear on that? Just say so if you're not.
One other piece of information I do want to is that I do represent the Board of Supervisors as county counsel. Carolyn Walker is an attorney for my office. She'll be representing the assessor. So we do keep those separate as is required under code. So that is why there are multiple attorneys on the line.
All right, thank you. Unless there's any further questions from the board, I will pass it off to the assessor's office.
Good morning. Thank you for giving us this opportunity for this hearing. I'm Shanna White, the Trinity County Clerk Recorder Assessor. We're here today because there's an appeal on property from Ms. Richards. The subject property, assessor's parcel number 17-330-09, is 141.41 acres. And there was a 50% change in ownership from Diane Richards to Diane DePaul, with a deed recorded paying $880 in transfer tax on February 13th. Document number 2018-0334. There was also a preliminary change in ownership included with that transfer. That P-Corps is what we call it in our office, stated the purchase price of $800,000 for 50% change in ownership of this property. Also on that P-Corps, there was terms of the sale were $100,000 cash and a $700,000 promissory note at 2.59% for 30 years. And I believe you got copies of all of those documents. The comparables my office used was APN 15-050-44. This parcel is 53 acres and was sold for $750,000 on the open market. And the sales date for this parcel was October 27th, 2017, just a couple months prior to the transfer. The other parcel we used for our comparables was 1510-330 and 1510-030 and 1510-032. This was a multiple sale transaction, but the total of the two parcels was 80 acres, and it sold for $875,000 on the open market with a sales date of June 27th, 2017. So both of those sales were in close time of the transfer that Ms. Richards did to Ms. DeBold. Ms. Richards supplied comparables in her request for exchange of information. Those comparables are not viable based on one of them, parcel 17-190-23. That property was sold on 7/31/28, which was not near in time and wasn't an open market sale. Parcel 15-250-01, this property was sold on February 14, 2018, so it was near in time, but it was not an open market sale. The other 4 parcels that Ms. Richards included were not even parcels in Trinity County, those were in Shasta County. That's what I have for you today, and if you have any questions, I'm here to answer them.
Are there any questions from the board?
Yes. So the transfer tax, what is the significance in the transfer tax that you've given?
Well, whenever a document is recorded, a deed is recorded, I'm sorry. Whenever a deed is recorded, transfer tax is paid on the purchase price of that transfer for the property. And it's based on 55 cents per $100.
Yes.
That's where the $880 came in.
And the significance of including that in this just kind of fact-finding portion would simply be that it verifies the price that was paid,
Exactly.
and the fact that that was paid without any appeal or, I mean,
When the document was recorded, that's what they paid. They paid transfer tax of $880 based on a sales price of $800,000.
right, I'm looking at the significance of that. Do I just think of, in other words, if you pay that, then we're all in agreement.
You're claiming that that 50% of that parcel is worth $800,000.
Somehow the math isn't, maybe I'm doing the math wrong here, but that doesn't look correct to me.
So are we saying 1.6, Shannon? 1.7?
But they only pay on the $800,000 that the transfer was, not for the whole parcel.
I'm just saying
I'm sorry, let me.
the 896 doesn't, how does that get to 800,000? That would be,
The 880. So 896 was to record the whole document.
right?
So $16 was to record the document, and 880 was in property, in
But that's-
transfer tax.
That would be $1 per 100.
Yeah. So we don't have to.
Pardon me?
That would be $1 per 100.
Yes, $1.10
You
per
said-
100.
You said
Yeah, you said-
55 cents per 500. So it's
Oh, okay.
55 cents per 500, it's the same as $1.10 per 100. R&T code specifies that it's 55 cents per 500.
500, okay. I misheard you then.
I'm sorry,
So we're generally going off the 1% average on the whole.
pardon me?
1% average on the whole. If it's 55, it's $1 for every 100, 1%.
Yes, basically.
Okay.
That math isn't working for me yet.
Shannon, is that a statewide use?
Yeah.
estimation?
Yes, it is, it's in R&T code, it's $1.10 per 1,000. 55 cents per 500.
Okay.
Sorry for the confusion.
All right, okay. So that number comes from the person filing the deed comes in and says, you ask what they paid for it, and you go from there, right?
Yes, they signed off on it on the preliminary change of ownership form, the P-Cord, that document is recorded with a deed. If they don't record that with the deed, they have to pay an additional fee. So, sorry, I need to pull up the correct one. So Diane DePaul, the buyer of the property, signed off saying she paid $800,000 for a 50% interest in this property. And Keith, that is on the second page of the P-Cord. It was given to you, I'm sorry, the preliminary change of ownership form.
All right, change it, okay. Second page, back page, okay.
And that was handed out to you, Jill.
Oh,
What page are we looking on,
I see,
Shannon?
okay. So this is what you received from Ms. DePaul, if I'm pronouncing that correctly.
Yes, when the document was recorded, that's what was received.
Okay. All right.
you're not giving me online. I have a couple extra copies here.
And Margaret, if I step over some line, let me know. This property is zoned what?
This property is unclassified.
Okay, thank you. And you said 140 acres?
Yes, 141.41.
I noticed in the application from the appellant, I believe they noted the land as timberland. Would that be incorrect then?
I'm looking at my appraiser right now, Jeremy, to get confirmation.
It is not in timber production zone property. It is not under that contract. The planning department determined the zoning and they have it as unclassified.
Okay, thank you. If the rest of the board didn't catch that, in the attachment to the item, if you look under the application itself, and you'll note at the bottom of page 1, it is noted as vacant land, and then it says other timber tract. So I guess that would technically be incorrect then. That's what I'm hearing.
Jeremy, I took that, it was just that I took that as it wasn't TPC, it was just a timber tract of property, but you are correct, yeah.
Alright. Well, because I've been told that TPZ you can default TPZ to a certain value based on a statewide assessment. Is that correct, Shauna?
That's correct.
Okay, thank you. Does the board have any more questions? If not, then I'm going to turn the floor over to the appellant. Last chance for any questions?
Yeah, does this change the 1% factor being timber or non-timber? No.
Are you talking the transfer tax?
Yeah.
No, it does not.
And then is Miss Richards or Miss, the other applicant and the appellant in the room, or are they zooming in?
They are here, Jeremy, and she's getting prepared to present to us.
And before we
Okay.
do so, let's make sure the clerk swears her in.
Please raise your right hand and repeat after me. I swear or affirm
I swear or affirm
that the testimony I'm about to give
that the testimony I'm about to give
in this matter is the truth.
in this matter is the truth.
Thank you.
Thank you.
All right, Ms. Richards, typically we allow for 10 minutes during a hearing, so do you feel that that'll be an appropriate amount of time for you?
I'm not sure. I didn't know that, I was not advised that it was 10 minutes, so I don't know how long it will take. I did hand in to the board here and the secretary, let's see, it's about 4 or 5 pages that I'm going to read to get into the record, plus an excerpt from the assessor's manual. So I don't know. I was not given that notice that it would be 10 minutes, so I'm hoping that if I
Okay,
run over, you'll bear with me.
yeah, it sounds good, no problem. Please go ahead.
All right, thank you, Diane Richards from Hayfork. First, I do want to note that I was not given notice of almost anything, even though I am the one that signed the application for the hearing for reassessment. The assessor sent the documentation to Diane DePold, who did not notify me whether she got it or not. I believe she didn't get it. She's been ill and been hospitalized and had surgery, etc. And when I asked the assessor why, eventually they did give it to me just last month. And I said, why wasn't I notified all this time of this ongoing procedure? And they said, because Diane DePold
sent it to them, but I'm the one that signed the actual application, and then the address that they were sending the documents to doesn't exist. So I just want to say that that's really a violation of the due process, I would say, that I didn't get a proper notice. Meanwhile, let me go into the rest. I just want to say that it's,
Ms.
you
Richards,
kind of need to firm it up.
are you requesting a stay so you can have more time to put this together?
No, I'm not, but I do want to register that it was not, I had to really sort of work under emergency circumstances, exigent circumstances to be
I understand
prepared.
what you're saying.
Okay, so, I don't know if, I can approach, but I do want to just give you a visual. May I approach with this for Susie? This is the parcel viewer of Trinity County's own parcel viewer system, and that is the property, so that you kind of get an idea of what it is and where it is. Sorry I didn't make a copy for everybody, but it's on your own parcel viewer system. Can you hear me okay? Okay, thank you. So we hereby petition you to reassess this assessment for the following facts. One, and I did give you this so you can read along or read later. Do you all have it? Okay, thank you. The choice evaluation resides in the assessor, subject to review by the board, who selected the market approach using recent sales of comparable property. The assessor presents two properties that are not like the property in question, which, although unclassified, is in actuality unapproved 142 acres of timber forest land with timber varying age stands and has been used as such over many decades by present and previous owners at an elevation over 5,000 feet, which, along with no county road maintenance, is not accessible for half the year, November through May, give or take, due to snow. The property lies along the highest ridge on a dirt road known as Deer Lick Springs Knot Road on the boundary of Trinity and Shasta counties. Its use is limited to the production of timber due to the extreme slope and rocky substrate. It also suffered damage due to the Lime Complex fire, where it was actually the initial strike zone of that fire. The two properties offered as a comparison by the assessor are A 015010032, which was 80 acres in Junction City, with a 3-bedroom residence with utilities and year-round access. B 015050440, it's 53 acres directly on State Highway 3 in Hayport, a level high-quality agricultural land used for grazing, which also has a single-family home, septic, all power, including 3-phase, a water line, and a 10,000 square foot cannabis cultivation permit. So I do not think that it is similar at all or comparable because of that, just those two facts right there, those two descriptions. Number 2, appellants provided several more apropos comparables in the vicinity of the property that are like, and that they are within the timber production zone, unimproved, and are at elevations so are similar in topography and geography to the property, although not as high in elevation as the property. That property runs along the ridge, so it's the highest point there and is quite inaccessible most of the year. A 017190230 is 112 acres of forest land, which sold for $18,000 on 7/15/2018. B 01525000100 is 56.4 acres of forest land sold for $155,000 on 2/2/2018. The next three, yes, they're in Trinity County, in Shasta County. However, my property is right on the boundary of Shasta and Trinity. You walk over the road and you're in Shasta County, and these parcels are right there, very, very close by. C 04231001700 is 37.8 acres of forest land, which sold for $25,000 on 10/21/2017. D 04239001300 is 50.2 acres of forest land sold for $155,000 on 7/25/2017. E 04231001300 is 252.6 acres of forest land which sold for $60,000 on 12/31/2018. F 04239001400, 51.8 acres of forest land sold for $150,000 on 5/14/2019. That particular area is very highly involved in timber production. That's what that area is for, and has been for a long, long time. There's lots of logging roads, a lot of logging activity in that area, and also we had a very big fire there this past year. I think it was called I can't remember right now what it's called, but I'm sorry, there's a fire right there in Deer Lake Springs, and in fact, that area is usually known as Deer Lake Springs, even though it's giving an address of Douglas City. It's always referred to as Deer Lake Springs. 3, the areas of inoperable land must be identified by the assessor. For the purpose of land site classification, inoperable means that any of the following circumstances are applicable. 1, extreme physical barriers prevent access. 2, legal or administrative restraints prevent access or harvest. 3, rocky ground, steep slopes, or sterile soil prevent growing or harvesting merchantable timber. And this comes from the Assessor's Handbook, the appraisal of timber property prepared under the direction of Standards Committee of the State Association of County Assessors of California, by Timber Standards Advisory Committee, California State Board of Equalization, and this was in 1965. 4, timberland, which we'll get to this thing where you brought it up, Supervisor Gross and Supervisor Brown. The definition of timberland, this is through the Board of Equalization. Timberland means any land that is devoted to and used for growing and harvesting timber and compatible uses. Compatible use is defined in section 51104 subdivision as compatible use is any use which does not significantly detract from the use of the property for or inhibit growing and harvesting timber. 5, under subsection C, the property is and always has been a timber-bearing tract. There is no income on said property until timber is harvested. No timber has been harvested for the duration of the original owner, myself, nor during the present ownership. There is therefore no revenue to be claimed, no income, no expenses other than the 2008 fire losses. And also we could not access the property last year because that road was closed due to the fire. 6, the transaction of the property represents a 50% interest installment in the property to Diane E. DuPold, which seller, Diane Richards, myself, is and remains the original owner transferor, in which seller received, that's me, 1/8 of the sale proceeds with a note in which no payment was due for 5 years. Appellants present this contract as cause to not evaluate the property for the full sale price, but rather for the market value due to the following text in the Assessor's Handbook. And this comes out of the handbook. The number of possibilities differences for any appraisal is endless. All characteristics of the subject and comparable properties are considered during the appraisal process. But the appraisal's main purpose is to identify and measure the differences that have the greatest effect on value as recognized by the marketplace. Among the elements of comparison are financing terms, condition of sale, market conditions, location, physical characteristics, income characteristics. Under financing terms, it says, the sale price of a specific property may vary from that of an identical property because financing terms differ between the two properties. Potential buyers of a property may be willing to pay more than market value to assume an existing mortgage with favorable below market financing terms. Conditions of sale. When sale conditions are atypical, the result may be a higher or lower selling price than would occur in a normal market transaction. For example, a family member may sell agricultural property to another family member, typical in farming families, at a reduced price. Estate and income tax situations may also cause the price to vary from that price paid by other active market participants. When atypical market conditions are detected in a comparable sales transaction, the sale should be carefully correlated to the subject property. Since market-to-private adjustments are more difficult to make, the sale should not be used if possible. Frequently, a limited supply of recent relevant sales dictates the transaction be used as part of the appraisal analysis. However, any adjustment made should only be done after careful research into the terms of the sale, buyer and seller motivations, and possible effects on the price paid. In the Assessor's Handbook, Section 401, Change in Ownership, and this was reprinted in 2015 of January, states, consideration is something of value that is exchanged for the property. Consideration is not limited to the payment of cash. It could include the exchange of other property, the assumption of a debt, the cancellation of an outstanding debt, or the creation of a debt. Further, nothing requires that the consideration be equivalent to the fair market value of the property transferred. While the transfer of property for nominal value may be questioned, the term purchase should include a transfer for some substantial consideration, even though the value of what consideration may be less than the full cash value of the property received. Point number 7, buyer Diane DePold's motivation to purchase a property was to sequester a pending tax obligation by utilizing the 1031 tax deferment of capital gains option under advice of her tax experts and her real estate attorney. However, DePold did not use a cash method. Rather, DePold used a finance document, a promissory note, for 7/8 of the transaction, which does not constitute a cash value, and the promissory note is attached to this document at the end. In below notated precedent case, the highest court opined all 4 of the high sales were of improved property, yet the assessor made no specific adjustments on that account. Appellants state that this is the same error made by the Trinity County Assessor. Additionally, applicable in this instance, the court opined, the applicant next argues that the assessor's method in valuing the Redwood property was improper in that the assessor and the board made no adjustments for cash equivalents, time, or other factors, and in fact did not know the terms of the sales. For the same reasons above discussed concerning the Midstate property, this argument appears well-founded. The assessor's appraisals report indicates no adjustments for cash equivalents or time as required by Rule 4, except for a lump sum adjustment apparently contained in the final value choice, a value somewhere in the middle of the values indicated by all 12 sales. For reasons outlined earlier, such a method is a non-compliance with Rule 4 and is disapproved. In 1969, the legislature enacted Revenue and Taxation Code Section 402.5 governing the use of comparable sales. The section reads, when valuing property by comparison with sales of other properties, in order to be considered comparable, the sale should be sufficiently near in time to the lien date, and the property sold shall be located sufficiently near the property being valued and shall be sufficiently alike in respect to character, size, situation, usability, zoning, or other legal restriction as to use, unless rebutted pursuant to Section 402.1. To make clear that the property sold and the properties being valued are comparable in value, and the cash equivalent price realized for the property sold may fairly be considered as shedding light on the value of the property being valued. And that was a case, Midstate Theaters versus County of Stanislaus. These above stated parameters, These above stated parameters in determining valuation should be applied to the property assessment as it comports to the intent of the California Legislature's tax code. Section 1 of Article 13 of the California Constitution states that unless otherwise provided by this Constitution or the laws of the United States, property tax rule or rule references are sections of Title 18 of the California Code of Regulations. A, all property is taxable and shall be assessed at the same percentage of fair market value. When a value standard other than fair market value is prescribed by this Constitution or by statute authorized by this Constitution, the same percentage shall be applied to determine the assessed value. The value to which the percentage is applied, whether it be the fair market value or not, shall be known for property tax purposes as the full value. Appellants request that the board adopt specific rules for the conduct of such hearings, especially directed towards outlining simple, orderly procedure in the interest of fairness, of saving time, and of preserving a record which will facilitate judicial review. And it goes on, tax proceedings are necessary, strictly construed in favor of the taxpayer, and there's a case here in the Supreme Court that it's quoting that. For the above stated facts, presented substantial competent evidence of values differ from the assessors and sufficient to make material the inquiry as to whether the assessor's methods of valuation were proper, such as comparable sales, finance terms, and unusual and extraordinary circumstances. The appellants ask the board to revise the assessment of the property and to make a proper adjustment as to fair market value. And then I have a footnote where it discusses fair market value. The legislature has expressed the concept of market value in sections 110 and 110.1 of the Revenue and Taxation Code 3, which were enacted to implement Article 13A of the Constitution. Section 110, subdivision A states, except as is otherwise provided in section 110.1, full cash value or fair market value means the amount of cash or its equivalent that property would bring if exposed for sale in the open market under conditions which neither buyer nor seller could take advantage of the exigencies of the other, and both the buyer and seller have knowledge of all the uses and purposes of which the property is adapted and for which it is capable of being used, and the enforceable restrictions upon those uses and purposes. And so as an example, may I approach again, or Susie? Sorry, far away here. This is on the web on one of the properties that she used as a comparable. And if you look at my property, it's basically trees and rocks, a lot of them. And so I want you to consider that they are not comparable whatsoever, and that these financial terms are not what it appears to be. Eventually maybe, but not now. And I actually doubt if I ever will receive that money. Do you have questions of me?
All right, thank you, Ms. Richards. Does that complete your?
Yes, unless anybody has questions of me.
Okay.
Should I stand?
Sure, you can just remain there, see if the board has any questions. Anyone on the board, speak up if you have questions.
Not at this time, thank you, for me.
Supervisor Cox, do you have any questions?
I don't right now.
All right, Supervisor Gogan,
Not at this time right now.
Supervisor Frazier.
Will we have another opportunity to ask questions of the appellant?
I mean, technically, this is the moment, and then the assessor's office will have a moment to respond, and then theoretically, I assume we could ask questions at any time, but unless otherwise noted, Margaret?
That's the chair's pleasure. If you want to ask rebuttal, have rebuttal or ask for questions after.
Okay. Well, I'll ask some questions. Ms. Richards, was there any board-foot assessment done on the timber value of that property?
No.
And so, correct me if I'm wrong, but after listening to your description of the events, it sounds like the buyer is utilizing this investment in half of your property and the transfer of ownership for bettering her tax outcome?
Yes, to exempt her from paying capital gains. And because she's not very well, I really don't know if she'll ever end up paying that.
Okay, and there was a promissory note included in the backup file? That's
Yes,
a
sir.
question for you.
No, Jeremy, the promissory note was not included in the original backup. That was additional information that was presented at the hearing today, and unfortunately, I'm thinking that we probably need to get a scanner in the board chamber so we can scan it and mail it to you when you're.
Can you just take a picture on your phone and text it to me?
Yes, I will.
That'd be awesome. Thanks. Are there any questions at this time from the board?
Is it not common practice to do what this lady's doing to avoid some of her capital gains taxes?
Who are you directing your question to, Supervisor Cogan?
I am not at liberty to give any tax
Okay.
advice.
But we will have an opportunity to ask more questions of staff, correct? Hear me? Okay.
The staff will then,
Yeah, it's fine with me.
well, the staff will have an opportunity to make a presentation if she likes or answer questions after. So yes, that will be coming next.
Okay. I will patiently wait.
All right, well, unless there's any questions, technical questions, I'm looking over the promissory note right now. Thank you, Susie. And Shannon, why don't you go ahead and you can have this time to respond.
Thank you, Jeremy. So a couple things I'd like to address. So Ms. Richards is correct. It was her and Ms. DePold who filed the assessment appeal application. Ms. Richards is the co-applicant that signed it. It was Ms. DePold who sent in the request for information based on RNT code 1606. Ms. DePold didn't, anywhere in her letter did not ask us to send back to Ms. Richards. So the response to Ms. DePold was sent on, it was received on May 14, 2019. My office responded to Ms. DePold on June 4th of 2019. And in that letter, and that's part of the agenda packet, in that letter we had requested more information because based on RNT code 1606, she would need to provide us information in order for us to provide information back. So not hearing anything from her and knowing we were going to come to hearing, on February 26th, my office again sent out a letter to Ms. DePold, and we also CC'd Ms. Richards on this letter. And then again on March 3rd, so on March 3rd, Ms. Richards responded. And then on April 8th, we sent information out directed to Ms. DePold, but CC'd Ms. Richards. So her comment that she got no information, no notices is incorrect. She did not get one notice because the request for information was received from Ms. DePold, so that's who we responded to. Ms. Richards also said that the parcels that we're using for comparables in Junction City have improvements on them. That is incorrect. Those parcels have minor improvements, so that could be anything. That could be a well or a septic or an outbuilding, a storage building. Our records do not indicate anything of a home site, a dwelling. I believe she said a 3-bedroom house. We have nothing on record of that, so that's why I consider that our comparables are viable. Once again, touching on Ms. Richards' comparables, I'll go back to say that they weren't near in time. The one that she talks about, 17-190-23, sold for $18,000. That was only a 25% change in ownership. So that $18,000 doesn't even represent the value for the whole property or the sale for the whole property. Her other parcel, her other Trinity County parcel is 1/3 of the size of the parcel that she is, that they did the transfer on. So, I mean, it's up to you, board, but I would advise to not change the value.
Or do you have any questions for Shannon right now?
I do have one. Is there anything that says that you have to stay within the county when you do your comps?
Well, typically when you're looking for comparables, you want to look at your county because your county is going to represent different ordinances and cultivation grows or logging. It could be different in a different county. So you typically want to find your comps within your own county.
So, Shannon, I'm trying to put this delicately here. It seems that we have a buyer that for other motivations than, let me put this correctly, than buying the property, put up a promissory note that Ms. Richards says she probably won't even pay back. So my question to you is, I know if somebody buys a piece of property, and if my mother sells me a piece of property for $1, you don't take the actual value of the property, you go out and find values. I'm not sure that I've ever seen a situation before where they're claiming that they overpaid by $700,000, and that was for a different reason than the property. Because normally when you pay for a property, that sets the value of the property, correct?
Correct.
And so, have you before had a case where somebody comes in and says, yeah, I bought that property for $1 million, but it was only worth $350,000. I just really like the guy because I'm going to give him extra money, but it wasn't because of the property.
No, Keith, I have not ever heard of anybody paying more than the property is worth. And I also wanted to add that I forgot to put in my presentation is this is the first time I've seen this promissory note. And typically when you loan money on land, you record a trustee. Nothing like that was recorded either. So I'm not sure what's going on with this property, but to answer your question, I have never seen someone pay more than property's worth just because out of the goodness of their heart, they thought that they should.
Okay, that's an interesting thing. But if somebody did, hypothetically, say, I really like that family and I feel sorry for them and I'm going to give them an extra $500,000, and you say, yeah, that's more than anybody else gets for it. It's perfectly legal to drop the valuation?
It is perfectly legal by using comparables. So you would, what properties are assessed on the fair market value. So the market value of what other like properties are being sold for and purchased for. And I feel that my appraiser did her due diligence on looking at this property and comparable properties and assessing it at a fair value, of accepting the sales price as a indicator of market. One of the properties that she used was 80 acres for $870,000. So that's, if a lot less than what the property acreage is that the subject property. So subject property is 140. She used an 80-acre parcel that sold for $875.
So just walk me through this part of it too. So this lady bought half of the property. So when you assess it, you're only upping half the assessment?
That is correct.
So you're not saying the whole property is worth $1.6 million now?
No, what was assessed at is that half a parcel was being reassessed and the original other half stays at the Prop 13 base year value and it gets factored each year.
Okay. So it didn't, so if the previous assessment was $100,000 for the whole thing, so you take $50,000 and then add that to the $800,000, that's where you got the $850 roughly?
That is correct, Keith.
Okay. And in some of this, there was a tax. It only went up $2,500, the actually tax bill. I don't have it in these sheets, but it was in the backup. You have this person that diligently prints everything out. So I didn't quite understand that its assessed value, of course this is a supplemental, so it must have been the timing of it. So the assessed value is up $745,000 and the appropriated rate, I've answered my own question, thank you.
Okay.
It was because it wasn't for the full year.
Yeah, because the event date was February 13th.
Right, okay. All right. I don't think I have any more questions at this time.
Shannon, do you ever find that
when you evaluate properties, half the property is worth significantly more than the other half due to sun exposure, flatness, terrain?
Well, it's really, Liam, based on the sale date. So what we do is we look at fair market value for that date of the transaction. So yeah, this property is worth a lot more for half of the acreage versus the other half because the transaction date was many years prior to this one. And we look at comparables on that transaction date.
Thank you.
Any other questions from the board?
I do have a question, and Shannon, just tell me if this is inappropriate to ask this question, and I will totally respect that, because I don't understand, right, never having been in this place before. But I am sitting here wondering, you said that there were portions of this that you had not seen, that had not been supplied, you didn't understand the reasoning, or had never seen the promissory note. I'm just wondering if you had seen any of that, do you think that would have changed the way this had gone down to this point?
I believe,
Again,
I'm sorry.
I would just want to be careful and be delicate, and you can say it.
Yeah, and you know, I never said I didn't understand anything. I did say that this is the first time I saw this promissory note.
Okay.
So would we have looked at that promissory note? We really look at the comparable sales more than anything. That's the biggest indicator of market value, is what's going on around that property. What other properties are selling within Trinity County to come up with our assessed value.
Okay, that makes sense to me, and I apologize if I put words in your mouth. I thought that I understood it to be that you had not understood the reasoning why they were entering into this agreement.
Oh, I do not know why they were entering into the agreement. That's what Diane just had said today, because of the capital gains issue. I don't, but that would not be a factor in assessing that property.
Okay, that's
We use comparable sales,
Yeah.
things that are comparable within the county.
Okay.
Supervisor Frazier, you got any questions?
Not right at the moment.
All right, and then, so Margaret, right now we can choose to go into closed session or remain in open session, is that correct, for deliberation?
Correct, I would confirm that you're ready to close the evidentiary portion of this hearing with all the board members. If they are, then you would ask if they'd like to deliberate in open or closed session. If they'd like to do it in closed session, we will then clear the room.
Okay, and Ms. Richards, do you have anything you'd like to finish with? I could give you 3 more minutes if you'd like some final words.
That's very kind, thank you, Supervisor Brown. I'd like to ask whether the assessor actually looked at other parcels right in that area that were timber. I know that there are some that are unclassified besides those being in the TPZ zone. Some are zone unclassified like ours. And I do want to state the reason why that unclassified zoning, from best of my knowledge, is there is because if you want to change it, you have to ask the board to do the zoning change, and it's quite a process. And for some reason, that parcel was left out, even though it was always a timber use parcel. If you look at the prior ownership, it was always timber companies, logging companies. So, you know, if there's a way to say, oh, well, then can I put it into timber zone, TPZ, without a big ordeal, as if you sign a piece of paper and you're in there, or do you have to have a formal hearing like this in order to do your zoning? Because I know most times when you do zoning changes, it's quite an extravaganza. And, you know, again, my parcel also was subjected to fire, and there was no reduction in its value, even though it partially burned in the Lime Complex fire. So I don't know, perhaps maybe Trinity County doesn't reduce values based on fire. But that is what happened there, and I do thank you again.
Ms. Richards.
All right, thank you, Ms. Richards.
What was the date on the Lime fire?
2008, I think it was July, August,
Okay.
or August.
All right, thank you.
Thank you.
All right, unless there's any questions from the board, we're going to go into closed session for deliberation. Margaret, can you, does the appellant wait outside the library chambers, or do we set a time to resume?
We do not need to resume. The appellant has requested written findings. So at this point, the evidentiary portion of the hearing will be closed, we'll deliberate, and then ultimately she'll be mailed the decision.
Okay, and Ms. Richards, you understand that then?
Yes, thank you.
Okay, thanks for coming in.
And thank you all for coming in for this.
Margaret? Margaret, are you still on?
So that will conclude the open session portion of this hearing. I figured the Zoom is about to close, and we will resume with closed session. Thank you.